we do have to have appropriate compliance measures. And the idea of data matching, introduced by Hawke, and the idea of automated letters being sent to people when there is a discrepancy evident from the data matching between the ATO data and the Centrelink data that was introduced by you is not a bad system. The methodology that has been used by this government is the same methodology that we inherited from you.
The High Court ruled, and insofar as the duty was said to stem from a proposition that the public interest can only be served if the case advanced on behalf of a regulatory agency does in fact represent the truth, in the sense that the facts relied upon as primary facts actually occurred, that premise is false for two reasons. In paragraph 42, the High Court took the view that each side in a criminal trial is free to decide the ground on which he or she will contest an issue. Proceedings for declaration of contravention or pecuniary penalty order engage no more stringent requirements. The same rules apply, so who decides? The question as to who decides the facts of the matter in a dispute was decided by the High Court's decision in paragraph 143 of Helicar. Deciding the facts of the case is a court's task, not the task of the regulatory authority. The Commonwealth Criminal Code Act, in section 142, subparagraph 2, deals with abuse of power by public servants. Now, paraphrased, basically this is what it says. A Commonwealth public official is guilty of an offence if the official exercises any influence that the official has in the official's capacity as a Commonwealth public official with the intention of dishonestly causing a detriment to another person. The penalty for this is 5 years. However, if somebody dies, then in South Australia, for example, that would be a felony murder, which would add another 25 years on top of the Commonwealth penalty, making a total of 30 years.
The High Court's Bargewar decision. In 2002, the High Court made a decision in Immigration Minister versus Bargewar at paragraph 53. As already pointed out, a decision involving jurisdictional error has no legal foundation and is properly to be regarded in law as no decision at all. Once that is accepted, it follows that if the duty of the decision maker is to make a decision with respect to a person's rights, but because of jurisdictional error he or she proceeds to make what is in law no decision at all, then in law the duty to make a decision remains unperformed.
In 1994, in the High Court's Coco decision at paragraph 8, the High Court ruled inconvenience in carrying out an object authorised by legislation is not a ground for eroding fundamental common law rights. In Coco, at paragraph 9, the High Court ruled a citizen's right to unimpeded access to the courts can only be taken away by express enactment. That means by a law passed by the Parliament to deprive people of those rights. At paragraph 10 in Coco, the High Court ruled the courts should not impute to the legislature an intention to interfere with fundamental rights. Such an intention must be clearly manifested by unmistakable and unambiguous language. The Australian Constitution separates the powers of the Parliament and the courts, and the Parliament therefore cannot pass legislation to deprive people of access to the courts, because the Constitution doesn't give them the jurisdiction to do so, and as the High Court ruled in Bargewar, if there's no jurisdiction, there is no decision. AAT Case File 2016-5334, submitted on the 21st of February 2017. If I am correct, over a time frame measured in decades, The Australian Federal Parliament has deliberately raped the civil rights of 4 to 5 million vulnerable Australians, and as a direct consequence of this systematic rape of rights, the unreported, secretly classified, officially irrelevant death toll caused by this ravaging of civil rights may be close to or even exceed 100,000 in number. Nol contendere. On the 22nd of February 2017, AGS lawyers representing the Turnbull government opted not to challenge that statement.